Get ready. 3 seconds. 2 seconds. Start. We are in this case concerned with the question whether the special judge / magistrate is justified in referring a private complaint made under section 200 CRPC for investigation by the Deputy Superintendent of Police, in exercise of powers conferred under section 156 (3) CRPC without the production of a valid sanction order under section 19 of the Prevention of Corruption Act, 1988. Full stop. Para. Aggrieved by the said order, the first respondent herein approached the High Court of Karnataka by filing writ petitions numbers 13779-80 of 2013. Stop. It was contended before the High Court that since the petitioner is a public servant, a complaint brought against him without being accompanied by a valid sanction order could not have been entertained by the special court on the allegation of offences punishable under the Prevention of Corruption Act. Full stop. It was submitted that even though the power to order investigation under section 156 (3) can be exercised by a magistrate or the special judge at pre-cognizance stage, yet the governmental sanction cannot be dispensed with. Full stop. Para. The High Court, after hearing the parties, took the view that the special judge could not have taken notice of the private complaint unless the same was accompanied by a sanction order, irrespective of whether the court was acting at a pre-cognizance stage or the post-cognizance stage, if the complaint pertains to a public servant who is alleged to have committed offences in discharge of his official duties. Full stop. Para. Learned Senior Counsel appearing for appellants, submitted that if the interpretation of the High Court is accepted, then the provisions of section 19 (3) of the PC Act would be rendered odious. Full stop. The Learned Senior Counsel also submitted that, going through the above mentioned provision, the requirement of sanction under section 19 (1) is only procedural in nature, and the same can be cured at a subsequent stage of the proceedings, even after filing of the charge sheet, and hence the requirement of previous sanction is merely directory and not mandatory. Full stop. Reliance was placed on the judgments of this court in R.S. Nayak versus A.R. Antule 1984 to SCC 183. Full stop. Para. The judgment referred to herein above clearly indicate that the word cognizance has a wider connotation and is not merely confined to the stage of taking cognizance of the offense. Full stop. When a special judge refers a complaint for investigation under section 156 (3) CRPC, obviously he has not taken cognizance of the offense, and therefore it is a precognizance stage and cannot be equated with post-cognizance stage. Full stop. When a special judge takes cognizance of the offense on a complaint presented under section 200 CRPC, and the next step to be taken is to follow up under section 202 CRPC, full stop. Consequently, a special judge referring the case for investigation under section 156 (3) is at precognizance stage, full stop. Para. A special judge is deemed to be a magistrate under section 5 (4) of the PC Act and, therefore clothed with all the magisterial powers provided under the Code of Criminal Procedure. The magistrate, who is empowered under section 190 to take cognizance, alone has the power to refer a private complaint for police investigation under section 156 (3) CRPC. We may now examine whether, in the above mentioned legal situation, the requirement of sanction is a precondition or for ordering investigation under section 156 (3) CRPC, even at a precognizance stage. Section 2 (c) of the PC Act deals with the definition of the expression public servant and provides under the clauses Roman 8 and Roman 12 para. The learned senior counsel appearing for the appellants raised the contention that the requirement of sanction is only procedural in nature and hence directory, or else section 19 (3) would be rendered odious. We find it difficult to accept the contention subsection 3 of the section 19 has an object to achieve, which applies in circumstances where a special judge has already rendered a finding, sentence or order. In such an event, it shall not be reversed or altered by a court in appeal, confirmation or revision on the ground of absence of sanction. That does not mean that the requirement to obtain sanction is not a mandatory requirement. Once it is noticed that there was no previous sanction, as already indicated in various judgments referred to herein above, the magistrate cannot order investigation against a public servant while invoking powers under section 156 (3) CRPC.